All right. Good afternoon, everyone. Thank you so much for returning to room 25 to join us for the kind of second, really third of the symposium. I hope you enjoyed your legal pedagogy sessions. Great to have you back in this room. I won't waste too much time talking a ton about our moderator for this panel, but I do just want to say this panel is going to be moderated by Professor Schwartz, who actually I have a very personal connection to. He was one of my very first professors in law school. He was a 1L professor. I had him for contracts in Zoom school in 2020. And this is a person who, I won't get into all of his expertise in insurance law and the other stuff. And instead, for the purpose of this symposium, just say he's one of those people that really exemplifies, a passion that exudes even over the internet through the screen to his students. And so I'm really grateful that he's here to kind of share that passion with you guys and with the panel for this symposium. So without further ado, indoctrination, alternatives to the case method.
Great, thanks so much. So I'm just going to start off by saying just a few very quick words, but really I'm going to let the panelists really be the focus of the presentation today. But I think that there really is a tendency that we've all sort of experienced to teach the same way we were taught. And so I think what's happened is there's been a real perpetuation of this method of calling on students and asking them questions, and to some extent doing it without knowing why you're doing it, right? That's just the way. And I think at the end of the day, what ends up happening is that when you follow that method, students get confused about what they're trying to learn, what they're should be taking away. And so over the years, the way that I've sort of adapted is, well, why is it that I find the Socratic method to be a helpful way of learning, and in what ways and when is it not? And what I figured out is it's a very effective way, or it can be, for keeping students engaged. But if you're gonna do that, the way that you have to operate is you have to tell them what you're looking for. You have to be willing to tell them when the answer is right or wrong. You have to be willing to step back and sprinkle in other methods as well, whether it's lecture, whether it's group work, whether it's working on a document together to write on it, whether it's discussion. And I think that sort of taking that more reflective approach on how we teach in the classroom is important, because too often we just do what we ourselves experienced. So with that just very brief introduction, I'm going to let the panelists be the focus of today. And so I'm going to start off by introducing Sandra Simpson, who's going to be our first speaker. She's a professor of law at Gonzaga, and she actually has written a book called A Short and Happy Guide to Effective Client Interviewing and Counseling.
That's me.
Oh, no, that's you. I'm sorry.
I don't think I wrote that.
Yeah, right. What I meant to say is Assessment of Teaching and Learning, a comprehensive guidebook for law schools. So obviously very pertinent to what we're going to be talking about today, and also serves as a director for the Institute for Law Teaching and Learning. So obviously expertise overlaps significantly with what we're going to be doing here. So I'll let you speak, and then I'll introduce our panelists as we move forward.
Thank you. Let me first say that the fact that Minnesota is using its position as a law review to talk about teaching and changing curriculum, I just think is amazing, and I'm so thankful to be here for that opportunity. So my article that I wrote that's going to be published is, all right, now, which way do I point this?
Just anywhere, I think.
Anywhere?
Close enough now.
Oh, perfect. So my article is called Law Students Left Behind, Law School's Role in Remedying the Devastating Effects of Federal Education Policy. And where I came up with this idea because I had noticed, I've been teaching for 15 years, and I had noticed maybe over the last 6 years that the students have changed dramatically, and those changes were more dramatic as the years moved on. And so I started to delve into why maybe that was happening. And there's a lot of factors, as you can imagine, why students change. There's socioeconomic, there's social things that are happening, but there's also the K through 12 education, which is what with my background in education, is what I chose to focus on. So a little background, since 2002, federal education policy has created students with these that have underdeveloped skills in critical thinking, cognitive adaptability, self-regulation, and problem solving. So by no fault of their own, our students, so every student we have, if they're of typical age for law students, were all started, because No Child Left Behind was passed in 2002. So all of our students have been in the K through 12 system in this country that is mainly generated by No Child Left Behind or Every Child Succeeds Act, which is the act that followed No Child Left Behind. So if by no fault of their own, students come to law school with these underdeveloped skills. And federal education policies have depleted those skills by, and so my point of the article is that law professors in law schools should adapt their teaching methods to the students that we have. And it's not the students' issue, it's an education issue. And so lawyers need these skills, and so my article looked at what undergraduate colleges are doing to ameliorate some of the skill loss, and then what law schools need to do to continue that. So, K through 12 education focuses on standardized testing, which is the problem. And it causes students to become very passive learners and task-oriented doers rather than self-directed, and resistant to learning methods to discover answers, usually wanting to know the answer, what the answer is, and that plug-and-chug learners, and they're highly skilled at memorization. And I know there's students in the room, and I love my students. It's not that I think you're somehow deficit, it's just that the educational system in this country has been focusing on the wrong things. And those things are being changed. There's legislation which hopefully will come up through the legislature this year that'll change some of that. But what happened when No Child Left Behind and the Every Child Succeed Act happened is that it forced, because it tied funding to how the students were performing on tests, it forced schools who were doing a really good job at testing and norm-based norm and criterion referenced assessment, force them to stop that and to change the way they were doing that. And this has been devastating to students who want to be lawyers. So I would say that existing in the gray is very difficult. It's difficult for everyone. It's even more difficult when you don't have a lot of practice at that. So in the article, I talk about a few ways that law schools, there you go, that law schools can encourage this critical skill development. And I'll talk about the teaching methods mostly, although I do have in the article several thoughts about changing the curriculum, but that would have been good for the last panel, but not this one. So I'll tread lightly on that one. So teaching methods designed to increase cognitive adaptability. And first I'll talk about what cognitive adaptability is. It's the ability to self-regulate your own behavior, your own thought process and problem solving in response to some feedback that you're given. And that's key to success for everyone in the professional world. So to arrive at cognitive adaptability, a student must learn to self-regulate and to think critically. Self-regulation is critical for the success for students, and it also helps to increase with intrinsic motivation, problem solving, and task interest. So the things that I talk about a lot of things in the paper, but I pulled out a few that I thought might be of interest to the people attending the conference. So modeling, I'll go through modeling self-regulating behaviors. The professor models that. Encourage students to engage in self-reflection, breaking down large projects into manageable pieces, and using rubrics to set students up for success. So the first one is modeling self-regulated behaviors. So I do this visibly in my classroom. So it's on all of my goals are set out in my syllabi, but I also start out every class period with telling the students, writing the goals on the board. And I'm really clear about creating assignments and assessments which talk about those goals or assessing those goals. And I'm clear with the students about what I'm doing. So I talk to them about that. And then I evaluate the outcomes that I see, and that I put up here that I visibly adapt and revise the educational process. So I usually tell them, I gave you this assessment, here's where I think we're still struggling, and then I self-reflect on my teaching strategies and talk to them about that. Here's the teaching strategies I use, but we're gonna try some new things. The professor's willingness to show that intellectual vulnerability is really important for students, and that goes a long way in helping students be vulnerable themselves, which is key to self-regulation and self-reflection. In my workshop that I just did, I told professors that were there that it's really important to not only model self-regulation, but it's really important to be wrong, make mistakes, and to own those mistakes, and to show the students how to move their way through professional mistakes. I think that that is part of creating this culture of self-reflection that we want to encourage. Encouraging self-reflection, I do this a lot with simple index cards. It's about the most simple assessment you can do. I often, probably once a day in each of my class, maybe every other day, I use these index cards. I have 77 students in civil procedure, and I hand out these cards to them, and I ask them to reflect on things. Sometimes I ask them to reflect on their performance on an exam, and then I give them specific prompts. Like, am I concentrating on learning the material? Do I understand the key points? What are my goals? Why am I here? What can I do to improve my own performance in learning? And having the students practice that self-reflection is really important to help them to focus on not whether they're doing well necessarily, but are they learning the material, and what are they learning from the mistakes that they're making. When students become more comfortable with self-reflection, if the professor visibly self-reflects on their own behavior. So when things go wrong in my class, we always talk about them, and I self-reflect on that. So this may seem obvious, but many students come to law school and haven't had the practice of chunking out their time or big projects. So for me, in legal writing, which I teach, I also teach Civ Pro and real estate, but when I teach legal writing, we work on one skill first, and then we work on the next skill, and I show them the process. This is how we work through this. And in doctrinal classes, the example I use is I teach students how to outline. Students don't come to law school knowing how to outline. They don't even know what that is. And so I assist them in learning their skills by breaking down the subject. And I do that on the board specifically. I'll say, this is how this fits into personal jurisdiction. We're on non-resident, getting personal jurisdiction over non-resident citizens. And then we talk about each piece of that. So I'm visually showing them how to break down these cases into subjects, not cases. And so I do that I also break down the course subjects, and I'm clear about what I'm doing. I always put that on the board, and then I look at their outlines, and it's really clear to see that they really want to organize by cases, not by subjects. And so having them learn how to do that is a way to help them manage time, break down the subjects. And they have to do that weekly so that they stay on task. Right, so the fourth method is using rubrics for learning. And what I do is I provide student examples which are annotated by my rubrics. If you went to my session before, I talked about this. I provide the rubric to the students. I facilitate self-assessment by teaching them how to self-assess. And I'm always open to listening to them by their self-reflections. And so what I do is I give them a 2-issue problem, and they write 2 different IRACs. They write them for both problems, and then they get one of them. I give them a sample answer, and it's annotated via the rubric. So it shows exactly what they're doing right and exactly what that student isn't doing in the sample example. So for example, if they're writing a sub-thesis, there are 4 things I require in a sub-thesis, and they know why I require it. We've talked about it. That's how I give them feedback. It's got this, and this, but it doesn't have material facts. And so the students learn that, and they learn how to self-reflect on their own work by being really particular and specific about that. And that encourages self-regulation. And the last one is provide opportunities for rewrites. Since most of my stuff is ungraded at the beginning of the semester, they always can rewrite that. The last one I'll talk about is really the changing the curriculum. So I'll just briefly go over that. I've got companion classes, and this has been used in a lot of STEM classes in many universities. There's a bunch of studies cited in the paper, but so I would suggest it be taught by a subject matter professor and then a teaching skills professor. So even someone from our main university who's an education professor to do that, because the students often don't transfer what they're learning in their skills classes to the doctrinal classes. And so if you can combine those two things and bring the skills into the doctrinal class, then they're learning the subject matter at the same time they're learning the how-to and the skills. And it really fits in with next gen and the things we talked about this morning, because it's not enough to learn the rules of civil procedure. You have to know why you're using the rules of civil procedure. And so drafting a complaint or those things, and many doctrinal professors don't feel comfortable doing that. And so that's my proposal would be to bring in people who are comfortable doing that and have those companion classes. So with that, additional ideas can be found in the article. It's available on SSRN, and so you can download that if you want to read it, or you can wait till it comes out in print from the Minnesota Law Review. But, are we taking questions at the end?
Yes.
Okay, thank you.
Great, well, thanks so much. So our next speaker is going to be Professor Sherry Lee Keene, who's a professor at Georgetown Law School. She was previously a federal public defender in Maryland, and her writing focuses on both criminal law issues and issues related to legal writing, advocacy, and psychology. And her recent work has explored how seemingly neutral laws can mask biased thinking. And I heard a great presentation from her earlier, and I'm looking forward to hearing what she has to say now.
Thank you. Thank you so much. Okay, hi. Thank you all for coming this afternoon and still being here today. So I'm going to try to modulate so I keep you all going. And I'm sure if I stop doing that, you will let me know.
I'll do a song and dance number.
Thank you. Okay. So today I want to talk about one of the issues that I think arises with case method or the Socratic method. And I'm going to focus particularly on the use of appellate cases almost exclusively to teach law. And the issues that I am identifying with that are, of course, there have been a number of criticisms, but mine is focused more on really our understanding of what an appellate decision is, how we talk about what it is, and how we treat it for students. So in class, you're often using that document, you're examining that document, you're investigating it, looking at the holdings, you're looking at the reasoning, and you're often doing a very intrinsic study of this document. And at least in my law school experience, that was kind of the realm of what I learned about a particular case, was largely confined to what was in the four corners of the document, just figuratively speaking. But there's some things that make that so that is not really a completely adequate or comprehensive way of looking at a legal issue. One thing is that, as we all know, or at least I think most people would agree, is that majority of opinions do not acknowledge all considerations that go into a legal decision. An opinion is a piece of writing. An opinion is persuasive, and it seeks to support and promote a certain outcome. And it reflects a series of not only analytical, but also writing choices, what to include, what to leave out. Of course, with the rule of law, that is also a framing feature, like the rule of law tells you what can come in or not come into a certain discussion. So the majority opinion carves out, because of the rule, a certain aspect of what's going to be discussed. But then even further beyond that, the judges decide what they're going to highlight or emphasize or bring to light in the decision, fact and primarily fact-wise, but also to some extent legally. So another thing is that the decision-making process and writing about it is not neutral. So we're often taking these documents at face value, but they can embed biases and assumptions, things that are not always unpacked, can exist within these documents. But yet they still treat themselves, or we treat them, as if they are neutral often and following clear logic. And we're not acknowledging really the writing as a result of compromise, and that we're often smoothing over conflict, disagreement, and even at times where the court is making a choice and deciding this is how the facts are, this is what the law is, that choice is not being revealed. I mean, many opinions are not. There are some judges, of course, who are known for doing this more than others, but many opinions are not showing that there were these two sides, and this is how they grapple, and this is the legitimate aspect of this one, and these are the good points that this person made. They may lay out the arguments, but not really the grappling between them, and they're not talking always about the choices that were made, and often those choices are largely buried. So what is the problem with this? Well, when we teach through examination of legal opinions and we do not acknowledge that these features exist within documents, we have a couple of things that we risk, and one of them is that we're following the same train of thought as the people who wrote the opinions. And so if the rule of law and the legal opinion leaves out the perspectives of marginalized people, which they do quite often, and we just use it at face value, then we are marginalizing students in the room who carry those perspectives. Now, when I was in law school, it seemed to be the way things would function. We would talk about something, whether or not it be something related to women or related to minorities, and we wouldn't talk about the actual issues, we'd just talk about the rule of law, and then everybody waited to see if the few people in the room who were minorities or who were otherwise situated with the circumstance would raise their hand and raise a perspective, because that perspective was not raised in the opinion. And the most creative, I guess, we could get was to hope someone who could more speak to that would talk about it, because it was outside the law. A heavy burden on students of color. I'd like to think things have changed, but I'm still hearing the same complaints from students, that they feel like these issues are not being raised, that people are looking at them to raise these issues in class, and that no one wants to talk about these issues or knows how to. And so it's just a concern that comes when the courts aren't talking about it, then we're talking about what the court's talking about, then where does that leave students who have other perspectives that are not represented in the opinion? Even more, the contrary perspective can be endorsed by saying it, by repeating it. That statement can be endorsed, whether or not intentionally or not, by the person presenting. And so that leaves me with the question of what can we do about it? Well, my focus has been in my writing on talking about bringing in other things to kind of show or problematize or show the issues with the majority opinions. It's not like every professor has to know how to bring it in. It's not that I know how to do that always. But there are places we can look that will raise those issues that I think we are underutilizing. So one way to do that is to bring in dissenting opinions, which we do at times, but to think about what those dissenting opinions are doing, not just offering the losing argument, but also telling us something about the majority opinion. The majority opinion maybe wasn't telling us. And I need the clicker, I'm sorry. Oh, that's good. I forgot I had a PowerPoint. I do that quite often, as I don't. And maybe it's best since I can't get it to function.
There you go.
Oh, there it goes. That was what was supposed to be up. Okay. And if I'm lucky, I can go to the next one.
You have to push it really hard.
Oh, okay, good. So just as by way of an example, in Utah versus Strife, that was a case where the Supreme Court decided it would allow illegal police stops, or it would not exclude evidence resulting from an illegal police stop, where the police learned after the stop that the stopped individual had an existing warrant, okay? So we know that the police violated the Fourth Amendment, but we're excusing it where the person had an existing warrant. In that case, many of you probably have heard about it because it was talked about a lot at the time, not because of the majority opinion, which wasn't particularly remarkable beyond its decision, but because of Justice Sotomayor's dissent in that case. And in that case, Justice Sotomayor did a number of things that really showed what the problems were with the majority opinion through her dissent. So this is the part of the dissent that is most often talked about, where Justice Sotomayor kind of breaks the third wall and talks about, here she's talking about the consequences that can flow from a illegal stop or from a stop. And she talks about the degrading nature of a stop. Not only is this interesting in and of itself, but it also speaks back to what was said in the majority about stops being a negligible burden, okay? It also speaks back to the way it was characterized as though stops were not a prevalent issue or that they didn't affect certain people more than others. She also does something interesting here. This is really where she breaks the third wall. When she says, do not be soothed by the opinion's technical language. And he's talking about the majority opinion. There's only so many opinions out there where the judge actually acknowledges that these are writings and that these are persuasive writings. And she's saying here, don't be confused by the way it's being presented by the majority, which is remarkable in and of itself. This isn't quite going as smoothly as I'd hoped because, okay. And then the other one is she also points out some of the language from the majority. They use the term as these are isolated incidents. And she kind of breaks down the idea of this being something being isolated. How can something be isolated when people are routinely targeted? So she speaks back to like the language and how a term, isolated incident, hid a problem that the majority decided not to raise and address. Okay, so the opinion does a number of other things. She also breaks down certain assumptions. The idea that someone with a warrant is a bad person. She talks about the number of warrants that are out there. She emphasized what this warrant was for in this case. It was for a traffic violation. And she does, I won't go into all the things she does, as I know I'm short on time, but the opinion is remarkable in the many ways that it allows us to see the majority opinion in a different way. When I was in law school and I wasn't often taught in that way, that here this is dissenting opinion is showing us the problems with the majority opinion, just more different argument. But I find it very helpful to connect the two in this way. So what do? We don't have the benefit of having Justice Sotomayor pointing out the problems in the majority opinion. There are other documents that show these issues. The briefs in the case, often the dissent is the product of these appellate briefs. And so you can go back to those and you can see what some of the issues are in the case. But the idea being that looking for ways to bring to the forefront what is not so easy to see. So I'll leave it there.
Great. So our next speaker is O.J. Salinas, who is a clinical professor of law at UNC Law School. He is the one who wrote a short and happy guide to effective client interviewing and counseling, and his teaching and research includes academic and bar support, legal research and writing, and negotiation and client counseling. So take it away.
Well, great. So I started teaching at UNC in 2011. At that point, Carolina had a purely adjunct-based legal research and writing program, and in 2011, they switched to full-time faculty teaching in the legal research and writing program, and I was one of the first ones there that was able to be hired. And I don't shy away from this. My pedigree is different than a lot of law school faculty. It's certainly different than the faculty at UNC, and that's fine. As we heard this morning, different is okay. Different doesn't have to be bad, right? And so, as was discussed in the intro, I've taught other courses. I've taught legal research and writing for about 6 years full time. I've also taught skills courses like client counseling and negotiation, and I've also been in sort of the academic support space since 2011. So my comments today are going to sort of focus on the sort of academic support wellness space as well as the practical lawyering skills space. And my hope is that you will find reasons to, if you are teaching a doctrinal class, you'll find reasons to try to incorporate some practical lawyering skills into your classroom. All right, so I'm happy to have been invited to participate in this discussion about reimagining legal education in a new era, right? Like, I think it's important for us in the Legal Academy to continue to examine what it means to provide a legal education, right? In the legal academy, we often, pride ourselves that we're training future lawyers. And as we heard, throughout the day, that we are, training lawyers to think critically, and we want them to think like a lawyer, right? But as we all know, lawyers do more than just think, right? They certainly do more than just think quickly and speak quickly on their feet. Lawyers, they counsel, they listen, they collaborate, they write, they research, they negotiate, they practice law, right? And the traditional casebook method approach to teaching often doesn't give students that opportunity to engage in the full range of skills or in several skills that the practice of law sort of involves, right? There's just a limited amount of skills that the traditional casebook method approach to teaching allows, and that can be problematic, right? The traditional casebook method approach doesn't really give students the message that there are other skills that are important to the practice of law, other skills that are potentially valuable and appreciated, that can be appreciated. Rather, the traditional casebook approach sort of benefits those students who tend to be stronger oral communicators, who perhaps have had the privilege to sort of speak freely and openly and confidently about their opinions and their views. And that could be discouraging and challenging for those students who don't have that privilege or don't have that sort of skill in terms of being a strong oral communicator. It can certainly be discouraging and challenging for students who may perceive themselves as being different from the rest of their classmates or who are different than the rest of their classmates. These students are still academically strong, and they have interesting and diverse perspectives and life experiences, but they may not be able to shine in what may feel like an intimidating and pressured classroom. And this can lead to students questioning whether they belong in law school. They may begin to think like I did when I was a 1L, not because my grades were not good, just because I didn't like the way the classes were taught. They may begin to think like, am I wasting my time doing this? Because I thought lawyering was something else. I thought I was going to do other things as a lawyer. They may begin to think that their stories and their skills that they individually possess, right, and can present are not valued in the legal profession. And so that's a problem, because that leaves a lot of students, again, a lot of students who have different life experiences, different skills, different perspectives, kind of leaves them kind of on the bench, kind of watching others participate in the classroom game. And then when they're sort of thrusted unexpectedly into the game in what feels like an intimidating cold call, they feel these pressures, right? These internal pressures that they may place upon themselves, and then these sort of external pressures, right? Everybody turns around and looks at you, and if you were like me, one of the few students of color in the classroom, there are these other pressures that you begin to feel. They start to feel like they have to prove to themselves and to others that they do belong in law school, and they can do the types of things that lawyers do, even though what's happening in the classroom is not really a lot of what lawyers do, right? They begin to think that they can't compete with their classmates and that they can't be successful in the law school classroom and in the legal profession. So providing alternatives to the traditional casebook method approach to teaching, like many legal writing assignments where students apply law to facts of a mock client's case, or even sort of simple sort of pair and share sort of oral presentations where students can sort of talk about the law, paraphrase the law in sort of a less intimidating environment where everyone's not sort of looking at you and waiting to hear if you say something wrong. That can give students the opportunity to shine, to show that they have skills that can be valued in the legal profession. It can show them that they belong, and that can be very validating for them. Providing alternatives to the traditional casebook method approach to teaching can also give students an opportunity to assess whether they are understanding what they are supposed to be understanding in the classroom, right? The traditional casebook method approach tends to have this sort of hide the ball kind of situation. I'm not going to tell you the law. I'm going to sort of ask you questions, so that you can sort of figure out what the law is. But there really is not a lot of opportunity for the students to figure out whether their understanding of the law is what they really need to understand until, of course, the final exam, which often is 100% of their grade, right? So providing opportunities to have sort of these assessments, right? Sort of whether they're, again, little mini writing assignments, little mini oral arguments, even sort of just multiple choice questions where they're having to apply law to facts, right? That are different from the cases that they're reading in the class. Can give students an opportunity to sort of figure out whether they understand what they need to understand. It can also give the faculty member an opportunity to figure out, oh, maybe I should sort of change things up a bit because a lot of my students are not picking it up the way I think they should pick up, right? And that gives students an opportunity to seek appropriate intervention, right? I'm in the academic support space too, so I work with a lot of students who have not sort of performed well or who don't think that they're performing as well as they should. But if they're never given that opportunity to sort of get that type of assessment, then it's typically after grades come out, right? So then those students lose a whole sort of semester of opportunity to sort of improve, right? If I can show you this at some point. There you go. So hopefully y'all are thinking a little bit about why you should, right, incorporate practical lawyering skills in your doctrinal classrooms. And if you're wondering sort of how, right, or I don't have the time to do it, or it's too much work, the citation that I'm showing you up here is a really helpful book. Tammy Olson's book, which includes a variety of contributions from a variety of professors, including our own here, Sherry, shows doctrinal faculty, what they are currently doing in their classrooms, in terms of incorporating practical lawyering skills into this broader doctrinal classroom, for all the reasons that I've talked about and more, right? I should say that I wrote a book review for this book, and it's in the journal Legal Education. And in the book review, I talk about sort of like a little client assignment that I would, client interview assignment that I used to do when I taught legal writing, that was a different way for me to assess whether the students were picking up the type of researching skills that I wanted them to pick up, whether they were able to sort of do the type of legal analysis that I wanted them to do, because they were actually they didn't realize it at the time, but they were doing legal application. They were applying law that I wanted them to apply to the facts of the case in the moment while they were interviewing the client and providing, counsel. So it's not, we heard this morning about sort of, I think John talked about sort of like there's some status issues, right, between sort of, legal writing faculty and skills faculty and doctrinal faculty, right? And so you see, here I believe I say sort of like, why the separation, right? There's been a lot of positive movement in terms of changes to the legal curriculum, right? Like more experiential learning, which is great. And that's been a positive step, but it's kind of also created this sort of separation, this sort of division between sort of doctrinal faculty, who are the faculty who are seen to sort of teach the law, and then sort of skills faculty, right, who are often paid less than doctrinal faculty and who often don't have the same job security as doctrinal faculty, who are tasked at teaching the skills, that students are going to be expected to do when they graduate. Yet skills faculty still work with doctrine. It's not like the skills are being taught in some sort of vacuum, totally isolated from the law. So my question, is, well, if skills faculty can work with doctrine and do work with doctrine, can doctrinal faculty find ways to incorporate skills as well? Because if we are law schools, right, presumably we are in the business of training folks to be lawyers and to practice law. And we've seen that the bar is sort of shifting priorities to actually like assessing skills that lawyers do, newly licensed lawyers. Then shouldn't we do that in most of our classes and not just in our skills classes? So I'll end there. I'm really happy to have been invited to participate in this discussion. I think it's, as was Sandra said, it's a really a great topic, and I appreciate the law review for bringing this up. So I'll end there.
Great. So our last speaker is going to be Beth Walensky. Beth was an associate at Aiken Gump for 5 years before she made her way over to the University of Michigan, where she's a clinical professor of law. And she's written broadly on a variety of issues related to providing feedback to students, to working with first-year law professors to sort of marry the teaching of doctrine and skill. And she's even implemented that with my favorite professor in the world at Michigan, Kyle Logue. So I look forward to hearing your thoughts.
I have a lot of favorite professors at Michigan. Kyle's one of them. So I'm happy to be here. I'm particularly happy to be batting cleanup because I think the thing, I use a lot of baseball metaphors when I teach because I'm a big baseball fan. But I think some of the things that I have to say are going to kind of pick up on some of the specific things that we've heard from my colleagues up here. So I have been teaching now for 20 years. I teach almost exclusively 1Ls, or have traditionally. I'm sort of branching out into doing some upper level stuff. But my experience is that when I was in law school, I thought it was fine. Socratic method didn't particularly, bother me. I didn't really I didn't reflect much on the case method as a means of teaching. It's really only been as, from the other side of the podium that I have over 2 decades now, teaching and talking to now hundreds of students about their experiences and then watching them go off into practice. That has really helped me understand where we as an academy can be doing better. So I'm going to give you 3 student anecdotes. These are all based in reality. I've changed some of the details a little bit just for student privacy concerns, but these are all quite representative of dozens and dozens of conversations that I've had with students over the years. So here's anecdote number 1. A student who, in their first year of law school struggled, actually struggled in doctrinal classes generally, did okay, not great, and then and did okay in my class, right? Wasn't like a standout student. And then, in their last semester of law school, did a clinic. And it was a clinic where they were, and the student had a background, came into law school having a counseling background before they came to law school. And the student got into a clinic and just knocked it out of the park. And I know this not only from talking to the student, but from talking to my clinical colleagues. When it came to sitting down with a client who was in a distressing situation and talking to that client, getting that client to open up and share information about a very distressing part of their life that they need this legal help for. We have a student who is able to listen and empathize, and as a result, it's not just, oh, isn't that nice that you have this nice relationship with your client, actually was a much better lawyer for that client than lawyers who can't connect in that way with clients. So that's anecdote number 1, right? That student's now, she's now an alum, right? And is out practicing law and doing a great job. Student number 2, student who did fine, right, in the doctrinal classes, but God, really just hated reading appellate opinions. And came to talk to me at one point and said, so is this what lawyers do? They just read lots of appellate opinions and apply them and write about them in these briefs and things like that? And there's one part of my class where I give my students a summary judgment assignment, and I have a whole record that they have with deposition testimony and documents and things like that. And this student loved mining a deep set of facts for information that they could then use to put together the pieces of a puzzle. And I said, there are lots of areas in the law that let you do that. If you're interested in fact investigations, if you're interested in different kinds of the practice of law, that you're really going deep into the facts and figuring out the legal significance of these facts. And I'm not going to tell you you're never going to have to read court opinions. That's a piece of it. But that's an extraordinarily valuable skill. And if that's interesting to you, then there is a good place for you in the law. And that student is now practicing and doing, again, great job. Third student is one who, again, had as a 1L in my legal writing class and really, did okay in their doctrinal classes. sat down and to write memos and motions for me, especially when we did the persuasive writing stuff that we do all second semester, and just had such a natural gift for telling stories in like really great, compelling ways. Could like write an introduction that was just captured the reader's attention and told the client's story in like just a couple of sentences that made you, got you on the client's side. And so all semester I was giving the student really just great feedback on how wonderfully they were doing, and just did such a great job in my class. And at the end of the year, I got an email from the student that said, "Thank you. I want you to know that your class is the only thing that made me feel like I belong here." And it I kind of get a little emotional, right? Like, what are we doing as a profession, as an academic profession, if we are making lots and lots and lots of students feel that way, feel that like, I don't belong here. And when I say these students, I mean students who we know are going to actually be really good attorneys, right? Because we know this, because I see this. I see year after year students going out into practice who felt kind of like a fish out of water with a lot of what we do in law school, for lots of different reasons, but one of the reasons is our pedagogy. And so the test that I've kind of developed in my head for is our pedagogy the right pedagogy, is something like this, right? If the way that we are teaching routinely and incorrectly tells law students that you're not going to be a successful attorney, you don't have the skills that it takes, the skills you do have are not skills that are valuable and are going to help you be successful as an attorney, then I think we're doing something wrong. So I have some specific ideas, and I will also say, I think sort of like in terms of terminology, let me start sort of, there are three kind of pedagogical methods that kind of ride in tandem, but I want to separate them out because they're different things. One is the case method, which I think of as like using appellate opinions to try to extract information about what the law is. Then there's the Socratic method, which is the sort of oral conversation where the professor asks the student a bunch of questions to try to like dig down on some topic. And then there's cold calling, right? Which is the stand up in front of the room and pick somebody out and say, I've got some questions to ask you. So those are three different things. They often kind of travel in tandem. But you can engage somebody Socratically on something that's not about a case, right? You can cold call on somebody and ask them about something that's about policy or whatever. So there's three different things, and I actually think there's value in all three of those things if used correctly and in moderation. I do a little bit of each of those things myself. I think the problem is that we overemphasize them, and in doing so, we send a message to so many students that the sign of a successful law student, and therefore the sign of a successful future attorney, is how do you handle the cold call on this, a case in class? And then how well do you manage the end of the term exam, whether it's like a 3 or 4 hour in-class exam, or maybe if you're lucky you get like a take-home exam of 8 hours or 24 hours or however, whatever it works at your law school. And there are lots and lots of things that attorneys do that don't look anything like that. Now, sometimes attorneys are called on to engage in those ways. I think it's much rarer than the message that we send to students by putting so much emphasis on these particular pedagogical approaches. So a couple of thoughts that I have in terms of specific teaching ideas, like what do we change? And if we're going to introduce more stuff like skills into our curriculum, one of the concerns is, okay, well, what are we going to take out, right? Because we can't do it all. And it may be that it means we teach less doctrine, but it also might mean we teach the same amount of doctrine, or at least not that much less, but what we teach differently. So I'll give it some examples. So certainly one thing that I think it's really important to do is to give students the opportunity to think before they have to respond, right? So just the act of saying, so I'm going to ask about X and Y and Z. I'm going to pause for 2 minutes and let you all give that some thought. Everybody take out a pen and paper or open up your laptop, or everyone's laptops are already open, right? Unless you ban laptops. And just write a couple of bullet points on what you think the answer is, right? A lot of students need that time to reflect, and, you know, sort of the ability to answer something really quickly. There's a particular skill in that, and some people are really good at that, but it's not really a sign of sort of intelligence in the sense that people who will come up with as good or better of an answer if given time to reflect, are, I think, every bit as likely to be really good attorneys if you need that time to think. But I want to give a specific example in thinking about what if we pulled back from the case method a little bit. So every year I teach in the spring semester a summary judgment problem, right? Again, I give my students like the complaint and a full set of like documents, like this is all the stuff that was produced in discovery. And when we start digging into it and start looking at like, you know, are there facts in dispute? Usually there's like, I write the problem so that there is a dispute about whether there are facts in dispute, right? Like one side is saying, look, there's no dispute about X. We said this, they said that. That's basically the same thing. And then the other side says, well, actually, no. There is a dispute here, and here's why it's material. And you sort of start to see like these like light bulbs kind of going off in students' minds because they've taken civil procedure. They've read Celotex, but they haven't had a chance to engage with the material in this way. So I kind of wonder, like, do students need to read Celotex, right? Like, what would happen if a professor said, okay, here's Rule 56, I'm gonna quickly summarize Celotex for you, but what we're really gonna do is spend class time figuring out how that works in the real world. What does it mean to say there's a factual dispute? What does it mean to say, yes, there's a factual dispute, but it's not a material dispute? What does that look like? I love the idea of giving students, as Sherry suggested, briefs from opposite sides of the case, so you can see how attorneys on two different sides use the same record and the same set of legal standards to argue, you know, sort of, yes, there's a dispute here, no, there's not a dispute here, or yes, there's a dispute here, but it's not material for these reasons. What would a civil procedure class look like that did that? That instead of using the case method for that particular class, where we're going to read and develop, you know, delve into Celotex and Anderson and Matsushita. Where's my civil procedure professor, right? Celotex and Anderson and Matsushita are the ones that I think about as like the trio. But said, you know what, like, instead of reading the cases, we're going to do something different to learn about this area of the doctrine. Not for every single thing we do, but for some of it to, again, mix up what we do a little bit more. And the last thing I'll say, this kind of goes to the course companion. What did you call it? Like the companion courses. Thank you. You know, we actually do a little bit of this, not like a full sort of like semester of it, but at Michigan, we've started looking for ways to do a lot more collaboration between doctrinal and skills professors, right? So and some of it's like motivated by me going out to my colleagues and saying, hey, you know, this is where Kyle Logue, my professor, my colleague at Michigan comes in, because, you know, when he has had my students for torts, when I had them for legal practice, I'd go to him and say, what are you doing in the second week of the semester? Because that's when I'm teaching CREAC, and I want to take the cases that you're using in your class and use them to build out a problem for my students, for our joint students in my class, so that they can learn CREAC without having to learn like a new area of law, right? Like let them be an expert in, and I would actually go to I've been to Kyle's class. I sit in on all my colleagues' classes. I invite them to sit in on mine. And I hear what he teaches them. I read the cases. I write a prompt. And now they've become like mini experts in this area of the law. So now they can learn the skill of how do you put that together in the service of advising a client, where they can focus just on the skill. And the other thing we've done, so we pull some doctrine into skills classes. We're also now taking the skills classes directly into doctrinal classes. We have what are called labs, where we will often have our clinical colleagues will go into civil procedure classes or contracts classes or some other classes and do, like in partnership with the civil procedure professor or contracts professor or what have you, a skills-based exercise, right? Like where they will talk through like, how do you write this part of a complaint? And then students will all write that part of the complaint, and then they will come to class and they will get feedback on it. So you know, those are kind of some baby steps kind of things. I know that we've heard lots of good thoughts today that it's actually not the time for baby steps. It's the time to take big giant steps, and I'm here for that too. But any steps forward are good steps. And so that's all. Thank you.
So we have some time for questions, which we wanted to have out, but I'm going to start things off. I think one of the biggest challenges here is not how to teach well. I think a lot of us understand that. I think it's convincing many of the folks who are teaching to actually work to adopt these strategies, because at the end of the day, it takes time, it takes trial and error, and it's oftentimes the case that, in my experience, many folks are resistant. And so I guess I'm wondering if folks have ideas on the panel about how do we convince professors who are teaching in the 1L curriculum to actually expend the effort to do what all of you are suggesting. I think there are a few options. One is just peer pressure. I've tried that to some success at my law school, but I've probably pissed off more of my colleagues than I've actually caused them to change. Another is just by making rules, and we've done that. Say we have to do certain things, but it's very hard. Most schools are very reluctant to actually pay people to do things like provide feedback. And then the other thing that I've thought of that to me is probably has the most potential, but it's the hardest to do, is to get students to demand it. And 1L students they don't know what they need, and then by the time they're at 2Ls and 3Ls, maybe they're aware enough to organize a symposium, but maybe not motivated enough, or maybe not confident enough to say, professors, why are you doing it this way? Why in most of our classes are we not getting any feedback? Like, I'm paying a lot of money for tuition. Shouldn't I be getting some feedback? Shouldn't I be expecting that? I mean, are there any other strategies, or any of those strategies seem like they have potential?
Well, one thing I found really remarkable in law school is how rarely faculty, at least in my experience, talks about pedagogy. And I think the most discussions that I have had in a law school talking about pedagogy was during the pandemic, where we talked about it all the time like it was normal. But you spend a lot of time talking about scholarship, but less about how you're teaching. And I think, we're in a community where we talk a lot about how we teach. Legal writing faculty, skills faculty talk a lot about how they teach, and then you go and you hear something and you're like, I want to do that. That sounds exciting. Or people say, I read an article and I really want to change how I teach. And I think if we had more conversations about what we're doing and had more engagement about not just what we're writing, but what we're teaching, I think that, and more, this is how I do it, then you know who to go to for, just like you had your presentation earlier. If someone on your faculty could say, hey, that's terrific, I want to do it like you did. They don't have to reinvent the wheel. But I think it's very hard to make changes without a template and without knowing who you can go to. And I've just always found that quite remarkable, that that's not happening on a regular basis. Maybe someone can explain to me why, but I think that would be really useful.
So I do think it's about teaching well. Just because someone has taught this way for years and years and years doesn't mean that you've been teaching it well. And I think that sort of presumption, just because this is the way it's always been, it has to stay that way is a wrong one to have. I think also, who is teaching, right? The majority of folks who are teaching at law school faculties have done well in law school, right? They're not the ones who struggle. They're not the ones who don't get it. They were not the ones who were shy to go talk to professors so that they could sort of better understand what was going on in class. But that's not who you have in your classroom, right? Not everybody in your law school classroom is going to be top 10%. And I think, the faculty who are making these curricular decisions, right? And making hiring decisions, all that good stuff, right? If they only have sort of one experience and you're like, well, why? Of course the students are getting it. I did fine in law school. I picked it up. It was not a big deal to me. That's the thought that the students that are sitting in your classroom, if that's what you think is happening, then then you're thinking wrong. So I do think it's about teaching well and finding ways to do it better. Just because you've done it this way for so long doesn't mean that it has to stay that way.
Yeah, I think there's definitely a lot of survivorship bias going on there. The thing that I found, or one of the things I found effective is actually reaching out and inviting doctrinal colleagues into my classes, right? Like, and in service of like this specific kind of collaboration where I go and I say, look, I see that, we have the same students this fall. Here's this thing that I like to do. And I introduce like this kind of like foundational analytical and writing skill. I'd love to use whatever you're covering in class that week. And then if you want to come to my, and I kind of invite myself to that class, can I come sit in? And then I invite them to come see what I do with it in my classes, right? And I have found in doing that the colleagues that I have approached to do that and who've come to see what I do have become some of the biggest cheerleaders for certainly our program and what we do and how we teach, but sort of start to see how watching students in my class use the doctrine they learned in their class to write a part of a memo, which is kind of what I have them do. They kind of crowdsource parts of a memo in my class. And they start to see the student who maybe didn't get it when we were having this back and forth in the doctrinal class. When you say, well, here's your client, now you've got to write this analysis in this particular way and try to extract rules from these cases that you're going to use to apply it to your client's situation. Now they see, oh, that student actually gets it when you introduce the material that way. And so I find that that's been at least somewhat effective.
So I know we're running out of time, but I'll bat cleanup this time. I'm actually more of a football fan, but I'll go with that.
3:30, so we have 15 more minutes.
Oh, we have, done. I could take up 15 minutes. I think one of the things that at Gonzaga that changed most for me is we adopted a unified faculty. And so now doctrinal professors teach, well, let's be real. Now legal writing professors teach doctrine as well. We have very few professors from the doctrine area that went to teach in the skills area. But one thing that I did not expect to happen, so I gave up my long-term contract and I went on tenure track for more pay and all the good stuff, but is that I've been at Gonzaga for 15 years, but now I have to justify my existence every year on tenure track. And so I have faculty come into my classroom, both in the doctrine and in the skills, and reviewing what I do. And several members of our promotion, retention, and tenure committee came to me and said, I had no idea that's what you were doing. Yeah. Like, I had no idea, and it's so powerful. Can you help me do some things in my class? And I was thinking, what? I mean, I've been the director of the Institute for, 12 years. What do you mean you didn't know what I was doing? And it goes back to, so it's a status question, I think, part of it. It's like, oh, the skills professors do the active teaching, the doctrine doesn't have to. But I think when they see, like you say, they see the power of the active learning and what we're doing, it's really powerful. But I also think the patience on the part of the people who know the change is coming and needed is really important. And I said that earlier, but I think change is really hard. And there's chaos that ensues in their heads and in hearts. And I think that patience of working through that process, recognizing it as being really normal, and normalizing that. Like, I do see why this is hard, and I do see it's uncomfortable. But I also think the bar exam changing and the ABA pushing down, that's going to be the key, because once every state decides, okay, we're going to start testing skills, then it's going to flip the way law schools are on its head, because then skills professors will be like, oh my God, help us. And that's what the doctrine will be. But I think, in review, I think status is really important, and I think pushing schools to, which obviously we've been doing for a long time, but pushing schools to unify the faculty is really important, because then people see what you're doing. And then I also think that patience of change takes a long time to happen.
Great. Well, let's open it up to the audience. Do we have any questions from the audience? If not, I can ask more questions. Yes. Do we have?
Not so much a question as a follow-up comment to what you said. I think that law students and lawyers in general, but law professors especially, tenure-track law professors, have very narrow comfort zones, and they really hate going outside. In particular, they don't want to ever appear as if they don't. So I think they're very reluctant lawyer that was like, well, I don't know how to negotiate. How would I incorporate that in my class? And it's really hard to get them to overstep that. I said this in the workshop a few minutes earlier. I have colleagues who until recent, now I think all of my colleagues know how to use Lexis or Westlaw. But there were people who didn't. And for 40 years had never bothered to learn because they were afraid. They were, that they wouldn't know how to do it. So part of it, I think, is trying to get them to come into a classroom and to see how it's done. But then to get them to realize that you can learn something different, even when you're 50.
Yeah, I mean, speaking of, so I think one of the things that helped me a lot in this arena is the fact that before I actually, came on the tenure track here, I was a fellow where I was teaching legal research and writing. So I did it for 2 years. And then when I came here, sort of at first, like, oh, this is completely different. And then I realized, gee, actually, a lot of what I was teaching as a legal and research and writing instructor is really important and missing. And I need to actually think about a more holistic approach. But it is very tricky to convince a lot of doctrinal faculty to do some of these. And a part of it for me comes down to incentives. I mean, and this is, you don't get more money if you're a good teacher. You don't get promoted if you're a good teacher. You don't get lateral opportunities if you're a good teacher. At most, you get, vague student appreciation. And a lot of times you wouldn't even know it. Like other colleagues, they don't know it, right? So even if students think you're good, like maybe like colleagues don't appreciate that. Versus, oh, you published in such and such, or you published these articles, or that's where all the focus is. And so I often think there should be more structured ways of actually rewarding what's important. And I think scholarship's really important too, but to me it's like 50%, 50%. And yet that's not at all how, my annual reviews go. That's not at all how, my reputation is built outside of the building. And so I just wonder if there are better ways of aligning the incentives, whether it's a unified track or whether it's some sort of merit-based pay that's linked to teaching, or what have you. But I think that's at the heart of the problem, because a lot of times, the way to maximize your own self-interest is to spend as little time as possible on teaching, and to just publish more articles.
Well, I'll follow up on that. Oh, sorry, there's a question. I'll follow up on that because you said maybe it's the unified faculty. And when I hesitate to say some of these things because I know there's students in the room, and I always think when they go to these things, it's like being at Disney World and finding out that your favorite princess is smoking in the back room. Because you like start to see, oh, there's lots happening that I had no idea. But, so you're seeing the underbelly of some of the things that we deal with as faculty. But I had this comment when one of my faculty members was reviewing, I asked him to review my 29-page self-assessment. And I said, I know it's a big lift. He's like, no, I'll help you with that. And then he told me, listen, no one's going to question your teaching. No one. So you can cut out half of what you said about it. Because what they're going to look at is your scholarship. And I'm like, no, I'm keeping the teaching stuff in there. Like, they're going to read all those 29 pages. They can skip it if they want. But, so even with a unified faculty, and I will tell you too that they've only ever watched me teach doctrine. They've never come into my legal writing class, and you're supposed to watch me teach. They've only ever come, in the 3 years they've done it, no one's come to my legal writing class. It's only been my real estate or Sympo. So some of these things speak pretty loudly, I think.
Yeah, let's go over there and then go.
I was just wondering about hiring of doctrinal faculty. How many doctrinal faculty actually have practice experience and have the comfort level with the skills versus having a PhD, and what the trends are there?
I mean, I'll tell you right now, we're going through the entry-level hiring market, and
Everybody is.
very frequently, practice experience doesn't register as relevant. What the thinking is, look, as long as you meet the minimum bar on teaching, you're good. We don't care, and then it's all about what type of scholar you're going to be. By and large, now, I actually think Minnesota is better at actually having a little bit more of a balanced approach, and I also do think it depends on the law school, frankly. And there may even be, well, I hesitate to say this, but I do think that more elite law schools, they care less about the teaching. And because there's more of an assumption that students will get it. But, I do think it's a real problem. Now, that being said, frankly, sometimes, very good teachers, they don't necessarily have practice experience, but it's a huge blind spot in our teaching, in our hiring. And it's not something that it's not only do we not consider it in hiring, we don't consider it in promotion. It's like, have you met the bar? Or are you not pathetic? If you're not pathetic, we don't care. That's all.
So I'll say, I hope our bar is higher than that. I mean, I've sat in a ton of hiring meetings. Like we do talk about teaching. The problem is that it's exceedingly difficult to assess teaching from a distance, right? I can assess scholarship, right? Like I read the paper, I listen to your job talk, and then when it comes to talking about the teaching, people are sort of at a loss for well, it seemed kind of engaging, right? They think they explain this piece well. It's hard to do. It's hard to assess teaching, right, with someone who's not already in your building teaching. So I will say on the sort of hiring thing, like I have a colleague who is an outstanding teacher, right, really good reputation, and says that they kind of want to go back to the students they had in their first year of teaching and give them all a refund, right? Like, I kind of feel that way about my first year of teaching. I don't think I was very good. It's something that takes a lot of time to develop. This is one of the reasons that I think the programs that bring people in to do fellowships to go on the doctrinal teaching market and say, go ahead and teach legal writing on the side too, are doing their students a disservice, because you want people who devote their professional lives to thinking about this topic and how to teach it well. But it's there, I think the best sort of like quality in someone who has the potential to be an outstanding teacher is a deep desire to be an outstanding teacher, right? You don't have to be the most dynamic person in the room. I think sometimes we overemphasize the really exciting and energetic. I can be exciting and energetic, but I don't think that's what makes me a good teacher. Sometimes the quietest person, the most reflective person can be a great teacher. It's really about wanting to learn how to do it well and investing time in it, and there's an incentives problem with that. But like, if you have someone who's like, I really want to be a good teacher, then great, we can give you lots of resources and talk to you and help you develop into being a great teacher, right? Not gonna happen your first year, but it's gonna happen every year, you're gonna get better.
I can address that question just quick, is that we have on our rubric, our hiring rubric, that they're teaching evaluations and things that we see from, and recommendations from people that they've taught with. But I've often thought, why don't we make people do some sort of fellowship or student teaching kind of thing? Because we don't allow teachers into a grade school or high school or junior high without student teaching. So why, and we get no practice. We're not, in PhD programs, they TA and they're in the classroom. And so I've often thought why we don't do that, have some sort of onboarding for teachers. But we do look at it.
Carol, Laura?
So a comment was made earlier about the increased amount of discussion we engaged in about teaching in the pandemic and post-George Floyd's murder, because we needed to talk about how to deal with those circumstances. And I think that's right. We did more. We had regular summer meetings talking about teaching because we all had to pivot so much. But I wanted to suggest another venue for those kinds of conversations. The most I've learned about teaching differently came in two places. One was participating in and ultimately leading a teaching program at the university where I was talking with faculty who knew no law. They taught something completely different, but we could focus therefore on the skill itself and on adult learning and about how to teach effectively in a classroom. And I had visits to my classroom, and they knew nothing about the substance, but they could say something about. I remember one of them it seemed like there was a glass wall in front of the podium, like I couldn't cross that, was the comment. It's like, oh, I need to move around the classroom more. So I learned a lot in that venue. And then on the law side, again, not talking, there can be anxiety talking with your colleagues about teaching, because it's admitting when, especially as a junior faculty member, where you're being judged by the others outside your law school. So in the ALS arena, talking with academic support people in particular, before there was a lot of talking across that line, because those are professionals who know a lot about teaching and who are trying to understand how our students are learning and seeing all the different methods and the meta thinking they were going through. So I think getting out of our own faculties, I mean, we have to, because when we talk with each other, we end up focusing on doctrine and substance, and really we need those on the broader teaching piece, and I think that's more possible when you get out of that little environment.
Laura, I think we have to go finish in a minute, but I'll give you the last word.
On structure, I can recall at least 3 doctrinal faculty members who had essentially, quote, research leads to do practice. So an institution can encourage doctrinal faculty to do that. And also, as a matter of structure, if you're doing annual reports to your dean, why doesn't the dean have a question like, what did you do this year to take a risk to do something new in pedagogy? Just make everybody answer it. And then they have to say something.
Michigan does that. That's actually, there's a question on our, actually a couple of questions about teaching on our annual reports, and it's good, right? Because we all have to answer it.
Thank you. Oh,
I was just gonna say, same with Gonzaga, we have to talk about it.
well, thank you all so much, and